The committee is resumed. Members, we now return to the Parole Extended Supervision Orders Amendment Bill. The question is that parts 1 and 2 and clauses 1 to 3 stand part. Reno Tirakatini has 1 minute 45 seconds remaining.
Oh, thank you, Mr. Chair. Just prior to the dinner break, sir, I was explaining how the report of the Attorney General, which clearly in the Honourable Christopher Finlayson's opinion, this piece of legislation is inconsistent with provisions of the Bill of Rights Act. So that's serious, obviously, sir. You know, we don't want to be putting through legislation which is contravenes or is at odds with the rights of everyone under the Bill of Rights Act. So, but that has to be balanced, I guess, against the subject matter and the nature of this legislation. And sir, at the start of my speech, I was talking about the different aims of sentencing. And clearly, this piece of legislation, sir, is very much on the side of protection, on the side of public safety. And so those considerations, I guess, are paramount, and they do supersede the rights of the individual. But it's not to say that the extended supervision under this legislation is going to be handed out, willy-nilly, sir, because as we look through the provisions of Part 1, the tests that the court has to apply to determine the high-risk nature and the seriousness, I guess, of granting these extended supervision, they're actually very, very hard mandatory tests. There's about 4 or 5 mandatory tests that the court has to basically convince itself of before it will grant this extended supervision, sir. So, Mr. Chair.
Reno Tirakatini.
Oh, thank you, Mr. Chair. Just over 1 minute wasn't enough. So, sir, what I do want to move on to now is that it is not only the Attorney General that expressed concerns around the Bill of Rights, but, sir, there was a working group of the United Nations that was here earlier this year and had a look through our criminal justice system. And this was one area, the bills which we've been considering today, sir, was one area where they did express concerns. And so, I think it's right that we do take heed of, a body of the United Nations which, has considerable weight. Ultimately, sir, the obligations that we enact through legislation, some of them derive from international law, some of them derive from our obligations there. So, again, I think the work of this working group is, in a way, it is consistent, because although they did express concern, sir, they said that it is justified. These provisions are justified if there are compelling reasons and regular periodic reviews. And, as I mentioned, there are stringent tests that have to be applied to justify the reasons for the granting of the extended supervision. And also there are periodic reviews that are built in also. So just to conclude my contribution, sir, I wanted to touch base on the contributions of a whanaunga of mine. He's very much an outspoken person in the criminal justice area, none other than Kim Workman, who's been around many years. But his think tank group, the Rethinking Crime and Punishment, he's also expressed concerns around, I guess it's more to do with the application or the operational side of these of granting the extended supervision, sir. And I can actually see his point, because in some ways there are a lot of operational decisions that are made, but we also want to ensure that with whatever conditions or stringent restraints are imposed upon offenders, that there is also an element of, I guess, rehabilitation. And that's why the use of voluntary groups that are specialised in these areas, which he notes through circles of support and accountability, those sorts of programs are very beneficial. So it's not about just sort of imposing stringent, rigid rules on the offender. It's also about ensuring that they do get proper support so that they, hopefully do turn the corner and will be able to, be a free, go back into society fully, sir. And lastly, sir, my very last point, sir, I do want to go back to the working group of the United Nations on this bill, sir, because although it might be not directly relevant to this part in the bill, I think in the overall context, I think it is very important. Correct. And that is the over-representation of Māori in the criminal justice system. Because Māori make up more than 50% of the total prison population, even though we're only 15% of the population. And in the case of Māori women, sir, they account for more than 65% of the prison population. So the reality is, sir, that offenders who will be fall within the ambit of this legislation will be Māori. It's, the statistics are there and plain to see. Sadly, as sad as it is. And therefore, I think I would encourage the government to take heed of the working group's recommendations around looking at the inconsistencies and systemic bias against Māori at all the different levels in the criminal justice system. And I think, this piece of legislation, whilst it is a necessary piece of legislation that we are enacting, I think we mustn't forget the overall context where Māori are very overrepresented in our prison population, and I think we definitely need to work to make sure that we can, reduce those numbers significantly. Thank you, Mr. Speaker.